welcome to Schiller and Hamilton Podcast. We are very honored today to have the founding managing partner of Schiller and Hamilton, Mr. Bennett Schiller, with us.
Thank you for having me, Kevin. I don't know about this honored part, but I appreciate that. But yes.
I'm glad you could make it.
Thank
you. And we're here today. I mean, as you've had, how long have you been practicing law?
26 years. So it's been a while.
It's been a while. And have you been handling, what we came to talk about today is workers' comp. Have you been handling workers' comp for that entire time?
For 26 years,
Okay.
yes. And I actually worked for a firm who did workers' comp while I was in law school in Columbia. So 29 years I've been working with workers' comp. In fact, when I was clerking, I actually got to write a lot of their appellate briefs, which was fun. So I learned a lot about workers' comp early on.
Seen a lot. Yeah. Okay, first let's just kind of give an overall 30,000 bird's eye view of what is workers' comp law.
Well, a workers' comp arises out of an injury on the job. So if you're working and you get injured while performing the duties that are required of you, then oftentimes that would be considered what we call a on-the-job injury or a workers' compensation claim. And it's kind of funny because a lot of people think they're actually suing their employer, which is not really the case. We are required, employers with more than 4 employees are required to carry workers' comp insurance. And it's literally an insurance claim, and you're filing a claim against your employer's workers' comp insurance company. And so if you've been injured on the job, you have an injury that arises out of and in the course and scope of your employment, then it would be compensable. That's the definition. And there's, an injury does not have to occur literally at one particular time. There doesn't have to be a specific event. And in fact, I had the opportunity back in '98 to try a case in front of the Supreme Court in South Carolina that reiterated and affirmed that the position in South Carolina is that injury by accident does not necessarily mean there has to be a specific event, that the injury could occur over time. And that case involved a forklift, and somebody tried the case before I got the case, and we lost on causation, but the Supreme Court agreed with our position. So injury by accident is an unexpected result because of some work activity. So it needs to arise out of and in the course and scope of your employment. So just because you have a heart attack while at work doesn't mean you have a workers' compensation claim. So there has to be an injury that is the result of some type of work activity, and the injury needs to be caused by it. So it needs to be most probably, within a reasonable degree of medical certainty, caused by that particular work activity. So, and there's all types of injuries.
Okay, so let's say someone has been injured at work. What is the first thing they should do?
Well, absolutely, the first thing they should do is report it to their supervisor or to the HR, but there needs to be a record. There needs to be a first report of injury that gets turned in or filed, but you have a 90-day notice requirement that you have to give notice to your employer. But I certainly wouldn't want anybody to wait 90 days. Report it immediately. A lot of times, and what we see are individuals who they think they've gotten hurt or they've hurt a pop or they injured their back and they walk it off. They don't want to get fired. They don't want to report an injury. So they'll clock out. They'll go home, hoping it'll feel better. It starts hurting worse the next day. They are scared to turn it into their employer. Perhaps they'll go a couple of days, and eventually it gets so bad that a spouse says you need to go to the doctor, you go to the emergency room, or you go to urgent care, and you still at this point haven't told your employer. It turns out that it was something serious. What you thought might have been, just a little strain. You didn't want to get workers' comp involved. Turns out to be very serious, a bulging disc or herniated disc. Well, that's bad because then you go and tell your employer that you need medical treatment, and an insurance company gets involved, and because you didn't report it immediately, they make the assumption that, well, you could have gotten hurt at work. You could have gotten hurt, at home, painting your house, working out in the yard. So it's very important that you give notice to your employer immediately. So if you suspect that you've gotten hurt on the job, my advice would be to tell someone.
Yeah. So would you agree with the statement that the longer you wait to report it, the more difficult your workers' comp claim can become?
Sure. Yeah. It clouds the water because workers' compensation is really designed to protect the employer as well as the employee. So it protects the employer because they get to control your medical treatment It protects the employee because it provides benefits that if you've placed yourself in harm's way, helping someone else or a company be able to make money, then they have an obligation to provide benefits if you get hurt while engaged in your job or your performance of your job duties. So the idea here is that your employer, because they're providing this benefit, they get to choose your doctor. So when you report it and you feel like you need medical treatment, then you need to ask them to send you to a doctor. You just can't run off to your family doctor, to the chiropractor that you've been to before, or run to urgent care, to the emergency room. Now, if you're in a car wreck or something, an emergency situation, and you get taken to the emergency room, that's a little bit different. But what we see the problem is, and the question that you had was, the longer you wait, obviously, the more opportunity for there to have been an intervening event. And, obviously an insurance company gets involved and they would love to be able to deny your case. I mean, that's how they make money, by not paying claims. So, the sooner you report it, the better. Seek medical treatment authorized by your employer or the insurance company. Because what the employer has to do is then they turn it into the insurance company. An insurance adjuster gets involved, and then that adjuster will then tell you where you can go for medical treatment. Or a lot of times your employer will send you to, one of the urgent cares, or one of the, like in Rock Hill here, it's Concentra, and Beaufort, it's usually Doctor's Care or one of those. So they're going to send you to a doctor. Oftentimes they're going to want to do a drug test because, that's very important to them. So they get to choose. They send you to a doctor, and you have to follow that doctor's orders, because another reason they can deny your claim is for you to refuse medical treatment. So you don't want to get in a situation where you go to a doctor on your own, or you don't follow the doctor's orders of the authorized treating physician.
So you need to go to their doctor. Let's say someone has been injured, they've reported it, they're now seeking treatment, and their injury is so severe that they are out of work for a certain amount of time. At that point, are they entitled to any compensation?
Well, they are, because there's three benefits that they're entitled to in workers' comp, and we're going to kind of hit on each of those. But usually, initially, what will happen is, if they're not written out of work, the doctor will put them on light duty. They'll say, you've got a back strain, or you've got this injury, or, but let's put you on light duty. So the injured person would take that to their employer. Their employer would make a decision whether or not they're going to allow you to come back and do light duty. And I'll give you a classic example. Somebody's working at Walmart. They get hurt. They're a stalker after hours. Walmart finds out that you're on light duty. Your light duty may become being the greeter at the front door, where you stand there, to give you a chair. You can alternate sitting and standing, and you're greeting people. You're checking the slips. So they either provide you light duty, and then if your condition continues to get worse and the doctor writes you out of work, then you'd be entitled to what is called temporary total disability benefits, which, just because you're out of work a couple of days doesn't mean they owe you anything. Temporary total disability benefits begin when you've been out of work 8 days. So if you're in 7 consecutive days. So on the 8th day, they owe you for 1 day of disability benefits. And then on the 15th day, they have to go back and pick up the whole 2 weeks. So when they pick up the whole 2 weeks, they go back, and the the temporary total disability benefits isn't your paycheck. It's 2/3 your average weekly wage. So, the thing, a lot of times people say, well, I work 40 hours 1 week, and some weeks I only work 10 hours. So the way they calculate that is based on 52 weeks prior to the date of your injury. They have to fill out a form, which totals up how much they paid in the 52 weeks prior to the injury. They average that up, and your weekly benefit for workers' comp when you're out of work, written by the authorized treating physician. Again, that's why the authorized treating physician. So if your doctor writes you out of work, you go to a family doctor and they write you out of work, and it's not an authorized treating physician, you're pretty much out of luck at that point. But if the authorized treating physician has you out of work, you've been out of work, let's say 2 weeks, you're entitled to 2/3 your average weekly wage based on the 52 weeks prior to the injury.
And if someone is written out of work and they're now receiving their check, their TTD check, how long can they expect that to continue?
Well, that typically is until the doctor decides that they can try to go back to work. And, oftentimes when they do initially get to the point where they think the their patient, is able to return back to work, a lot of times they'll return back to work on light duty or half days. They say, well, you can't work 8 hours a day, but we want you to go back and work 4 hours. Mm-hmm. So at that point, they'd be entitled to what we call temporary partial disability. And temporary partial disability is a little bit different. So they're getting a paycheck every week, but they're not getting the same number of hours, or they were brought back to work and the employer doesn't have light duty and they're not going to pay them the same wage that they were going to pay them. They're going to pay them less. So at that point, the individual will be entitled to what is called temporary partial disability, and that is 2/3 the difference. So each week, the workers' comp insurance company will be required to look at your paycheck, and your average weekly wage, like we talked about a minute ago, the 52 weeks. They would owe 2/3 the difference. So that's important. A lot of times people go back to work and they say, yeah, they brought me back to work, but now I'm only working, 4 hours a day, and I was working 8 hours a day and sometimes longer, and I was working overtime, so I'm making a lot less. What am I supposed to do? So we see that quite a bit, where the insurance adjuster never really starts gathering or receiving the pay stubs showing that they've only gotten so many hours. So it's important. That's one of the reasons you get a lawyer, because we know these things.
Exactly. So once someone has been released to go back to work, is that the end of their workers' comp claim?
Most of the time not. Most of the time they'll go back to work before the doctors release them from care. So what happens is the doctor will treat. He may refer you for an MRI. He may send you for physical therapy. And one of the things that we see right now, that the workers' comp insurance companies, they're denying treatment. So the treating physician says, I think they need 6 more weeks of physical therapy. The adjuster says, I don't think I want to pay that, so we're not going to authorize that. So a lot of times we find ourselves fighting these types of things, or they will refer someone to an orthopedic doctor, and they're like, we're not going to pay for that, and so we have to get involved. So even though you're back to work doesn't necessarily mean that your treatment's over. What the doctor's looking for, and what workers' comp bases, closing out a case, or the time to close out the case, is what we refer to as maximum medical improvement. It's called MMI. And so once you've reached MMI, then the doctor has to fill out a form called a 14B. Mm-hmm. Now, in that 14B, which is very interesting, has more than just the impairment rating. So you got to think about this for a second. So an impairment rating is based on American Medical Association's guidelines, and they go through and they're looking at basically your restrictions and your medical condition, and they determine what percentage. So each of our body parts have a different number of weeks associated with it. And so if you have a back injury, he's going to say that you have a 10 or 12, 15% impairment to your back. And then at that point is when we try to either get the case resolved. And on that 14B, he'll also list work restrictions. Mm-hmm. He'll also list, the 14B asks the question of the doctor, is there any additional treatment that this person needs? So he has at MMI. And maximum medical improvement basically just means that the person has plateaued, that he's gotten as good as he's going to get, or she's going to get, and any treatment after this point is really palliative care. It's not curative. So it's not getting them any better. So they've reached the point the doctor says, I've gotten you as good as I can get you. And that's just in basic terms. And so that's when it's time to start looking at ways to get the case resolved.
And speaking about getting the cases resolved, what are the things when trying to negotiate a settlement or resolve the case? Can you speak on the different ways that a workers' comp claim can be settled?
Well, there's several different ways. One is by going to a hearing and having a commissioner tell us what the value of your permanent impairment. But so under workers' comp, there's 3 benefits. There's medical benefits for any medical treatment that reasonably tends to lessen your disability. There's the weekly, while you're written out of work. We talked about those, the TTD and the TPD. The final benefit that you're owed is for something called permanent partial disability, your PPD, and it could be perm total, so it could be permanent total disability. So at that point, what we are looking at, because it's the term disability. You notice I didn't say impairment, right? Yeah. So there's a lot of confusion between. So somebody gets a 10% impairment to their back, well, that's different for everybody, right? So, and I'll give you a classic example. So you got a 22-year-old roofer who's been doing heavy lifting his whole life, and he's been a painter, he's been a roofer, he's been a framer, has very little or no education. He's 22 years old. He falls off the roof. He ends up with a 15, 20% impairment to the back, but he also has no climbing, no stooping, no bending, no lifting restrictions. Mm-hmm. Well, that's going to have a greater disabling effect than, let's say, the accountant or the lawyer who trips over a banker's box full of files on his way out the door, to go meet with a client, trips over the box, face plants, injures his neck, ends up with the same impairment rating of 15%. Well, that 15% for the lawyer or the accountant or banker, that's not going to have the same disabling effect as it would for the roofer. So workers' comp pays you for the disability. And kind of like in a Social Security case, you have to look at the totality of the circumstances in order to determine the disability. So you take that 14B, you look at the impairment rating, the restrictions, and the future medical expense, and then you take into consideration the age, occupation, the job training. You look at all of these factors to determine whether or not or what the actual disability is for that person, right? And then, of course, we've got a statute which goes and lists, all of the scheduled members, all of your body parts. Our State House, in their infinite wisdom, has decided that each of our body parts are worth a certain number of weeks. And so workers' comp, the permanency that workers' comp is paying you for is typically designed to replace income that you may lose in the future because of your work injury. So there's two ways to settle the case. And I know I went the long way to get here, but so there's two ways to settle the case. There's one you can settle on 16 or 16A, which leaves open your medicals for a period of 1 year in the event that you have a change of condition, okay? And so that doesn't mean they have to pay for your medicals for the rest of your life unless you're permanently totally disabled or you've got hardware or a prosthetic device, and we'll talk about that in a different podcast. But so you got a 16A, and you have what is a full and final settlement agreement. And that agreement we always refer to as a clincher agreement, and essentially the workers' comp carrier can basically buy that risk. So instead of them being responsible for any change of condition or any future medical expense, they can settle out the case and have no more obligation to the injured worker, and it closes out the case. Now what we see a lot of times in these situations, and I'm not real pleased with the way they've been doing this recently, is they're demanding or requesting a resignation, which really shouldn't have anything to do with the on-the-job injury, but they typically don't want that worker back. Sends a bad message to other workers, hey, he still kept his job, he was able to come back, or they're worried about re-injuring himself or injuring someone else. And I'll give some insurance carriers are better than others, and I deal with them, and I've been doing it for 26 years, and there's some that are really good, and there's some that are just not very, very good at all. But so that's why it's really important to have a lawyer, because you're giving up a lot, and insurance companies would love to settle with an injured worker without a lawyer involved, because they don't know all of these different things. And a lot of times, they'll try to settle with someone, but they still owe back TTD. Like the person was out of work for 3 months and they never paid them for those 3 months, or they came back to work and they were paid a lot less than they were being paid.
Something that person would not know about.
Right. And so,
and the insurance company definitely is not going to bring it up.
Most of the time I find they're not going to volunteer information. They enjoy the fact that you don't know what you don't know. And so, having done this for 26 years and have tried lots of workers' comp cases, one of the benefits of having a lawyer who handles workers' comp, I think sometimes lawyers who handle personal injury, think that they can handle a workers' comp case because it's just like a personal injury case, but that's so far from the truth, because it's very particular. It's a very narrow kind of practice area, and because it is, if you do workers' comp, all of the attorneys and all the adjusters, they know who you are, and we work together over and over on cases. Sometimes I've got the same attorney on 4 or 5 or 6 cases, and so having someone who's actually tried a case, and I've tried a lot of cases. And, I'm not afraid to go to a hearing.
Yeah.
The commissioners know who I am, and they know that if I'm at a hearing, or if you're at a hearing, Kevin, they know that it's something serious that's in dispute, and we're not just there wasting their time. And your reputation with the commissioners and these other attorneys become very important, because they're not going to take you seriously unless you're willing to take a case all the way. And like I said earlier, I've taken one early in my career all the way to the Supreme Court of South Carolina, and actually had oral arguments in front of the Supreme Court. So the attorneys and the commissioners, they know that case gets cited on appeal quite a bit. So, biggest thing to do really, Kevin, is if you think you've gotten hurt on the job, report it. If they send you to one of their doctors, you need to go to one of their doctors. And at that point, you probably should get a lawyer involved. The sooner we can get involved, the sooner we can make sure that you're getting the proper medical treatment, that you're getting the proper weekly benefit. Because sometimes, and I've seen this happen too, where you've only been on the job for, 8 weeks, and then you end up with a compensation rate, a comp rate, that's not properly calculated. So, getting a lawyer involved early, I find, is very helpful, certainly for me as the attorney. And of course, we're not going after your employer.
Yeah.
A lot of people think that, I like my job.
It's important, yeah. It's not, again, like you said, that is important, because I hear that a lot from people, is that they don't want to sue their boss. They
Right.
like their boss. They need to understand that it's not your boss.
Or they need their job. They're worried about losing their job.
Get fired.
And if they get fired for filing a workers' compensation claim, then that's a wrongful termination.
Yep.
So kind of summarize, and because I've been doing this so long, there's a lot of mistakes that are made in workers' comp. You get hurt on the job, you go to your own doctor, you don't report it, or you lie to your doctor. Here's another thing, Kevin. We see this all the time. Because you're afraid of filing a workers' comp claim, you tell your doctor, you make something up, because you don't want it to come back on your boss or your company. You love the company you work for, and that's great. I want people to enjoy. I run a law firm, and I want people to enjoy. But if they get hurt on the job, I want my insurance company to do what I've been paying my insurance company to do, and that's to insure my employees. Yeah. So, again, report it. Don't be afraid to get fired, because that would be improper for them to terminate you for that. Be honest. Make sure that when you go to the doctor, you tell the doctor what happened. Yeah. Tell them that you got hurt on the job. Explain to them how you got hurt. That needs to be documented as well, because if they come in and deny your case and say, no, you didn't get hurt on the job, it's nice to have my client's testimony consistent with what's in the medical record. And I'll say that again. The client's testimony, when they come in and talk to me, when I get that first medical report and it's something different, I've got concerns.
Yeah.
And rightfully so. So either the client is being untruthful to me, or they were untruthful to the doctor. And a lot of times they were untruthful to the doctor because, they didn't want to get in trouble.
Yeah, they're worried. So, thank you very much for that overview of workers' comp. As you can tell, workers' comp can become very complicated. So thank you for listening. And anyone out there, if you or anyone you know has any questions or has been injured on the job, please reach out to Schiller and Hamilton.